Good morning, everybody, and welcome to Avoiding Harassment in the Workplace, the fourth in the series of 30-minute breakfast briefings with me, Kaz Carrington of KLC. Mariana Honorato of GoHo is providing technical support today, and Melanie Whittle of KLC will be answering the questions that you post as we go along. If we don't get to answer all your questions, of course, then please email us at klc@klcemploymentlaw.com. and we'll email you a response. Okay, so off we go. First slide is obviously just a slide telling you that it's avoiding harassment in the workplace and it's a 30-minute webinar. I will try to keep to that today. Liabilities and remedies, we'll talk about the statutory defence, the definition of harassment, when's banter, not harassment. We'll look at some case law, but only a little bit in relation to our statutory defence and protected characteristics. Other types of liability for harassment, like under the Protection from Harassment Act, what the Equalities and Human Rights Commission have to say in their technical guidance and their code of practice with regard to discrimination, and then I'll end with top 10 tips. So first off then, let's look at who's responsible and how that works. So as employers, we're responsible for all situations that we control. So that could be if we place an advertisement, we've got primary liability for that. But we also have secondary liability for our employees and what they do in the course of their employment. And as many as you will know, in the course of employment has quite a wide interpretation, has been given a wide interpretation by the courts. We also can be responsible for our contract workers. There are, if you like, freelancers, contractors, those LIMBY workers, and agency workers. Even though agency workers aren't our workers, they're the worker of an agency. If they are acting under our authority, then they're acting as our agents, and we may have liability for their actions. So we have to be aware of that. And then, of course, there is this old chestnut of the third-party harassment liability. Now, that was repealed in 2013, our liability for that. Government felt that it really wasn't necessary to have that added protection. Since then, case law has very firmly told us that there isn't that protection there for people who are subjected to harassment from other parties. So not just people who work in your organisation, but maybe people who come into your organisation, or if your folk go out and meet other people responsible for the acts of those other people. So if they went to a meeting, if you have maybe somebody making a delivery and they said something untoward. Now, currently there is no protection, but they will be in the future. The government have said they will reinstate this. So what this means is we have to have a strategy for making sure our employees know how to deal with such things if they happen. Okay. Let's talk about individual liability as well, because not many employees are aware that they are responsible for their own actions. And indeed, if they are involved in harassment and indeed harass people in the workplace, they may be named on an ET1. That means that they could be respondents. They could be the second respondent after you, the employer. And if they are found to have committed that act of harassment, they can be liable financially as well. And this is always a good way of really reminding people that it's not just that they have rights in the workplace, and they have obviously responsibilities in the workplace to be nice to everybody and not to do such things as harassment, but also that they have liability, and that's both in the form of a judgment and any financial liability. And as we know, if both the employer and the individual employee are found to be liable, it's joint and several liability. Okay, so that's the way that works. So how do we as employers make sure that we can protect our workforce, make sure that people don't harass each other, but also make sure that the organisation is protected from claims of harassment? Well, as I mentioned, if we are going to be responsible for anything that's done in the course of employment, that's a bit tricky, because how can you be with people 24/7? How can you control everything they say and they do? Well, under the Equality Act, Section 1094 of the Act, there is a piece that says that if we as employers have taken all reasonable steps to prevent an act of discrimination or harassment, then we may not be liable. And that is what's called our statutory defence, sometimes called the first steps defence. And that's why we put together good policies and procedures. We try to educate our workforce to make sure that they do behave appropriately. And I think most reputable organisations have got their ducks lined up in the row over the years and would say, yes, I've got an equal opportunities policy. Yes, I've got a dignity at work policy. Yes, I talk to my workforce about these things and I remind them to look at the intranet. Now, a case fairly recently has really set hairs running, and it's the LA Limited versus Galen case. And in this case, we have a situation where there is an act of racial harassment, allegedly, and the organisation tried to say, look, this person is saying that they've been harassed. That may be the case. However, the person who is the alleged harasser actually underwent training, actually underwent education about such things as harassment. And that was within the last 2 years. Now, they thought that that would be enough for them to say, look, we've taken all reasonable steps, nothing else we could do. But the courts disagreed. Now, this was an ET case that was then appealed to the EAT. And the EAT found that although the harasser had undergone training in the last 2 years, that training had become stale and wasn't contemporary. And I think this is probably fairly damning. This is what the EAT judge said. It's not sufficient merely to ask whether there's been training. Consideration has to be given to the nature of the training and the extent to which it was likely to be effective. If training involved no more than gathering employees together and saying, here's your harassment training, don't harass people, now everyone back to work, that's unlikely to be effective or to last. So we start thinking about not only is this a training appropriate, but has it sunken in? Has the person taken on board the content of the training, and how long will the effect of that training last? So we're considering how effective the steps that have been taken were likely to be then when they were taken, and where appropriate, how effective they've proven in practice. That's what the EAT said. And quite interestingly, they drew an analogy with COVID-19 vaccinations. And they said, we're not just interested in whether the vaccination will elicit an immune defense response, are we? We're interested in how long that defense will last. And that's the same thing with regard to this education, this training about not harassing people, not discriminating against people. It's how long will that last? And looking at making sure that that is fresh, it's renewed, and it's contemporary as well. So we'll come back a little bit to that in a while. So who is protected under the Equality Act? It's employers and workers as well. Now, agency workers are actually not our workers. They're, as I mentioned, the workers of the agency, but they are actually protected under the Equality Act. So we are liable for them if they are subjected to harassment. And as you know, if we are found to have been liable, if we are going to lose a case, then compensation is uncapped. However, how is it calculated? Well, it's all to do with losses if we're talking about the compensatory award. So that's calculated in the same way that an unfair dismissal claim for compensation would be calculated. It's what the person has lost. So if the person has a sort of modest salary, then they're not going to be awarded millions of pounds. It's what they've lost and when they might reasonably expect to get another job. But remember, there's also that potential award for injury to feelings, and injury to feelings awards have no bearing at all on financial loss. They're just what the person has suffered with regard to the behaviour. How hurtful was that to the individual? And that is calculated on the basis of the Vento bands. And there's 3 bands. And if we're talking about harassment, it's usually on the basis of somebody has been subjected to what we might call a campaign of harassment. It's not just a one-off issue. And that would be in the highest band of Vento. And that would be between 27,400 and 45,600 in terms of an award. Now, of course, that isn't capped, but the tribunals have to have a good reason for going higher than that. There's also aggravated damages that can be awarded, and that's where the individual has been subjected to sort of dismissive behaviour or oppressive behaviour throughout maybe even the employment tribunal. And indeed, that's what we saw in Taylor versus Jaguar Land Rover. Rose Taylor was awarded aggravated damages was for the way that I guess that JLR conducted themselves during the tribunal. Many of you will know that, you know, there was this issue of, well, was there an equal opportunities policy? Where was it? And they did discover it, but it was only when they were giving final submissions. So those sorts of things obviously are taken into account when we're looking at compensation for the individual. So what does harassment look like? How is it defined in the Equality Act, and how can we know when it's occurring? Well, it is unwanted conduct always, which really distinguishes it from what we would call banter, when two people are giving as good as they get. It might be unacceptable behaviour and we may want to stamp all over that, but that would not necessarily be harassment because it's not unwanted. So it's this unwanted conduct that is related to a PC. Note, not because of a PC. And related to gives us a wider liability effectively. So related to a protected characteristic that has the purpose or effect, doesn't matter whether the alleged harasser meant to do it or it was by accident, it's the purpose or effect. And the purpose or effect is of either violating the person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So it's either of those things. So either saying to somebody face to face, you know, for example, I don't want to work with women because I don't like women, obviously that's violating their dignity, or actually just sort of, you know, telling a sexist joke or a homophobic joke to a group of people who you don't really think, you know whether hold any views one way or the other, but you're still creating that environment that if people think, well, actually, I'm gay and I was going to come out in the workforce, but I'm actually not going to come out at work now because it's clear that, you know, they tell jokes here and it's maybe somewhere I'm not going to feel comfortable. So it's either or. Now, just to make sure that people don't run away with thinking, oh, crikey, you know, you can't say anything, it's a charter for the easily offended. The Court of Appeal has been very clear about these words, and the words being, you know, intimidating, hostile, degrading, humiliating, offensive. And the Court of Appeal said, look, take these words at their everyday meaning. They are strong words. It's not somebody who gets looked at in just a bit of a funny way. That might be, as we come on to talk about other things later, microaggression, but it's not necessarily going to amount to harassment itself. So we get this definition, we understand what that looks like. And remember, related to a protected characteristic, and just reminding you, these are the protected characteristics. And of course, as we go through life, Equality Act now was implemented in 2010, so we're sort of 11 years on. As we go through, the meaning of those protected characteristics can change. It can be given wider, different interpretations. And we've seen that, haven't we, in the Taylor Jaguar Land Rover case, where gender reassignment has been given a wider definition by the employment tribunal, and it's likely to continue to have that definition. So rather than just being somebody has transitioned and that's a permanent state of affairs, the judge in the case said, well, actually, no, gender reassignment, it's more of a journey. It's more fluid than that. So people who are gender fluid would be protected under that protected characteristic. Also, think about the protected characteristic of religion or belief. Belief having to be a philosophical belief, and philosophical belief is often debated in the tribunals, courts. And we've seen ethical vegans being taken to be having a philosophical belief. The most important and interesting case so far on this subject is the Forstater case, which was heard in the EAT a couple of weeks ago. The appeal was heard, and this is all about whether somebody's belief in trans issues, this particular person's belief is that sex is different to gender, for example, And that is being debated as to whether that should be protected as a philosophical belief. So the point being here is, when the judge in the Galen case said it's got to be stale, that training, if you haven't updated it, that's what I mean. It's got to be contemporary. We've got to take into account recent findings, recent definitions, phraseology, the way we talk to each other, and making sure that what we're saying to our employees and workforce resonates with them, it has meaning. Otherwise, it's not going to be an effective defence. And otherwise, actually, they're not going to know how to behave. And that means that other folk won't be protected. They may be subjected to unpleasant treatment. Now, just to complete this, sexual harassment, we often hear about sexual harassment and people sort of say to me, why is sexual harassment singled out as being sort of special? Why have we got a code of practice or a technical guidance on sexual harassment and not other forms of harassment? And I guess it's because sexual harassment has a much wider definition than the other forms of harassment. So not only is it where somebody's engaging in unwanted conduct, it's also where somebody's engaging in conduct of a sexual nature. And conduct of a sexual nature might be defined as inappropriate touching, inappropriate jokes, intrusive questions about somebody's sex life, for example, those types of things. And that conduct, that sexual conduct of a sexual nature has that effect of creating that intimidating, horrible, hostile environment, or actually violating that person's dignity. Now, the Act goes on to define sexual harassment further as well, so it's got even a wider definition. It could be when somebody's engaging in unwanted conduct of a sexual nature, or that's related to gender reassignment or sex, and that conduct has that horrible effect, and then because of or rejection or submission to that conduct, the person's treated less favourably than they would be if they hadn't rejected or submitted to that conduct. So that means that if somebody is being coerced to enter into a relationship with somebody at work, and because they do enter into that relationship, or because they reject those advances, they are then subjected, if you like, effectively to a detriment, they're protected as well. So sexual harassment has that much wider definition. Now, I mentioned thinking about banter and harassment, and when is it banter and when is it harassment. And I mentioned that if somebody is actively engaging in that banter and giving as good as they get, then there will be no protection, certainly under the law. And this is really set out at this particular section of the Act, section 26(4), because this is the part of the Act that really advises and informs us of when it is harassment and when it isn't. And this might help us actually when we're looking at grievances and issues in the workplace. First of all, we have to consider the perception of the person. You might have a complaint. Somebody might say, I feel that I have been unlawfully harassed. It's their perception. You can't take that away from them. That's how they feel, but it is subjective. The Act then tells us to go to the next part, which are, what are the circumstances of the case? Was that person really a victim? Were they being subjected to this unwanted conduct that created this horrible environment, or actually violated their dignity? Or were they actually really engaging themselves in that as well? So what are the circumstances of the case? And having found out the circumstances, was it reasonable for the person to have felt harassed given those circumstances? Well, actually, you said some pretty awful things and you instigated that, and now you're complaining. Would that be taken as harassment in terms of a claim under the law? No, it wouldn't be successful. Would we actually punish just one person in those situations, in that banter? No, we wouldn't. Would we actually take some action to prevent that kind of behaviour at work from both of those people or a group of people? Yes, we would, but it's distinguishing in that way. Now, what do we need to do to bolster up our statutory defence and make sure that in doing so we are protecting all our folk in our organisations? Have those appropriate policies and procedures. Dignity at work, you might call it bullying and harassment. You might have a separate sexual harassment policy and procedure. The guidance from the Equality and Human Rights Commission says either have a separate policy for sexual harassment or mention it as a separate piece in your overarching harassment policy, so you're quite clear what sexual harassment looks like. educate the entire workforce about those policies and procedures. That's not just saying, yeah, have a look on the internet, yeah, you've all done it, you tick that box. This is not a box ticking exercise. That Galen case is quite clear. We've got to be more proactive than that. We've got to advise about their rights, their obligation to other people, and their liabilities, and making sure the content of our education, our training, our briefings is up to date in the way I've suggested. It's reflecting societal norms, not sort of out of the way, oh, this is just one person's thought on this thing, so we'll tell everybody about that. It's just actually as society changes its views about things and the law through case law gets changed, we reflect that in the way we, if you like, educate our workforce. We allow them to understand those protected characteristics, we explain them. So yes, you do treat people with dignity. We want to be nice to each other, but also they're protected in law. And remember, as things move along, we take a more nuanced approach. We don't just talk about, well, harassment is unwanted conduct, and this is what it looks like, and direct discrimination is where you treat somebody less favourably because of. It's actually saying, well, you can make people feel uncomfortable by more subtle ways. So I'm sure you're all aware of, this sort of approach of understanding microaggressions. In themselves, they might seem really not that sort of harmful, but they could be patronising. They could actually undermine confidence. And actually, over a period of time, if somebody is subjected to those, even what might seem, by the giver of those comments kindly, actually over a period of time that could undermine people's confidence and could amount to harassment under the law. So we are keeping up to date. Not only are we keeping up to date, we're rolling that out regularly, but we're also checking understanding. Again, that's what happened in the Galen case. They did the training, but they didn't really check how effective that was. So what about, you roll out your training and then you have a questionnaire a few months later. Has anybody been subjected to harassment? Does anybody, feel comfortable that they understand what these policies, procedures are, the training actually meant? So checking understanding is really a very good idea. Now, just for completeness, clearly it's not just claims under the Equality Act that we might be liable for. The Stalkers Act, as it was called when it was implemented, the Protection from Harassment Act, is perfectly capable of being brought in an employment context. And that was made clear to us by the Supreme Court in the Majowski and Guy's and St Thomas's Hospital case. And this is where somebody is subjected to distress or alarm on 2 or more occasions. Now, what we know is the Court of Appeal have said, look, this sort of behaviour has got to be such behaviour that might justify, a kind of sanctioning criminal law. So it's got to be something that is, fairly serious. However, that is possible to be liable for that employment. Now, why am I saying this? Is because usually we know that discrimination claims, harassment claims, they're time limited, generally speaking. I know that clearly the tribunals can allow cases to run if they believe it's just and equitable to do so. But generally we have that 3 months time limit. With claims under the Protection from Harassment Act, we're looking at 6 years for the claimant to make a claim. So just be aware of the possible liability for that as well. And of course, if we don't deal with harassment, if we don't deal with bullying, complaints effectively, we may then be subject to another type of civil claim, and that is personal injury claim. And that is where we might be seen to have been in breach of our duty of care. That would be we didn't deal with the harasser effectively. That harassment led, if you like, that breach of that duty of care, which was the harassment, led to the injury. The person might have sustained some sort of psychiatric damage because of that. They might be incredibly anxious. They might be suffering from some sort of mental health problem because of that harassment. And what's more, it was foreseeable. It's foreseeable because the person being harassed told us about it and we did nothing. Personal injury claims run in the civil court, 3 years in which to make that claim. But they could be run as part of a discrimination claim at tribunal, and that would be part of a injury to feelings claim. the same sort of no capping out effectively, but range of sort of vento band there. But in this case, the individual only has to show a causal link between the harassment and the injury, no foreseeability. So in that respect, it's easier for them to run. Okay, so my top tips then for avoiding harassment in the workplace and making sure you've got a robust statutory defence. First of all, number one, understanding what your obligations and your liabilities are. Who are we liable for? What category of folk? And really, what do we have to do to protect them? So ensuring our policies and procedures are comprehensive, they're up to date, they're legally compliant, they talk in sort of contemporary language, and that individuals have access to them, not just, well, look at it if you want to, but we are reminding them about these policies and procedures, and they're easily accessible. So if I've got a worry, if I've got a complaint, I think something has happened to me, I know where to go. And obviously, you know, really engendering that environment where people feel that they can come and talk to you. So ensuring that we've incorporated all the advice from the Equality and Human Rights Commission, that's both their technical guidance and their code of practice with regard to discrimination, into our policies and procedures. And again, you know, what I mentioned about making sure sexual harassment is properly defined, and that was one of the pieces that came out of the technical guidance of the Equality and Human Rights Commission on sexual harassment. Be aware, things aren't set in stone. They change all the time. I'm sure you're aware of that. Keeping up with the terminology, keeping up with the ideas, making sure that your message is contemporary, especially if you have a younger workforce. Some organisations do have a lot of very young people in their workforces, and you know, you will have to make sure you're speaking their language. Now, often people think if you have a younger workforce, people are less likely to discriminate. Actually, that might be true on one level. They might be more savvy with regards to discrimination, but on another level, they might be more casual in the way they talk to each other, they behave with each other at work. And that can get them into difficulties because they haven't quite got into the fact that actually maybe I shouldn't be behaving in that way at work. So be aware of that. Educating and engaging our workforce so they understand the importance of being respectful, nice to people, and what is and what isn't acceptable behaviour. Make sure your managers, I mean, obviously we're talking about educating the whole of the workforce here, but make sure your managers recognise when a complaint is being made. So often we hear something was said to a manager or a supervisor and it was sort of really just tossed aside. Nobody really took much notice of that. So making sure that people recognise something when it's being said to them and they understand the importance of letting it go, that if we don't act, we could then make ourselves liable. If we do act and we take all further steps, then we could make sure that we are able to have that statutory defence, and making sure people understand how to complain and the importance of doing it straight away. And we heard a lot about this, didn't we, in sort of historic sort of claims of sexual harassment. Well, of course it's important, and yeah, I want to know if something happened to you 3 years ago, but actually I want to encourage you to complain as soon as it happened, because if you leave it too long, with any investigation, memories fade. That information isn't readily available, and I may not be able to get to the bottom of this potential harassment if you don't come to me straight away. So we encourage people to do things straight away. Keep ourselves updated with the law, case law. Remember, it changes all the time, and that changes the way we interpret the law. Remember the changing definition of protected characteristics. Update our policies and procedures as required on a regular basis, roll out again and again and again. It's not just good enough to do it every couple of years and not change anything. And then after your training, after your education piece, check understanding. Do that by way of, it doesn't matter, questionnaire, whatever way you want, an anonymous questionnaire. Find out if that training, if that education has had the desired effect. And if it hasn't, maybe ask the question, find out what hasn't resonated and change your piece, your education piece, your training piece accordingly. Okay, well, that's all I've got time for today. We've had our 30 minutes, but just to remind you, please, before you go, obviously, if you haven't been able to get your question answered, do email us. That's klc@klc employmentlaw.com. Can also remind you that we're recommencing the Law on Tour in July, and we're doing that in many formats. We're doing that as a face-to-face, we're doing that as a virtual classroom, which will be fun, and we're doing that as a webinar. And that's a brilliant, complete employment law update in one day. And so do get yourself signed up for that. And get onto our website, the KLC website, or just email us at klc@klcemploymentlaw.com to find out more. And thank you so much for joining us again today, and I look forward to catching up with you again in June for the next breakfast briefing. But for now, goodbye. Have a fabulously sunny bank holiday weekend. Thank you very much. Bye for now.